Welcome, I'm Jean Manas. Most faces are familiar here, therefore, by extension, I would hope that I would be familiar to most of you. But for the few folks who I'm meeting for the first time, my wife Rebecca Haile, here, and I are delighted to welcome our friends John Bessler and his wonderful wife, Amy Klobuchar, who is on her way. She's just getting off a train to get here. She said she had to leave a meeting with the president early to make it. Back to New York City, and to be co-hosting this special event with the Strand bookstore, one of the most important and valuable institutions in New York City, and the last bulwark against the Amazonization of our existence. I would like to thank Nancy Bass-Wyden, owner of the Strand, for co-hosting this event and for her support in making it a success. By the way, I have this all down in writing because those of you who know me know that this is going to get very outrageous very soon, and I wanted it to be precisely outrageous. When Rebecca, Nancy, and I discussed over dinner last year the possibility of having this event at the Strand, Nancy warned us that attendance would likely be light. When I asked how light, she said she would expect perhaps 10 people or so based on her experience. Taken aback, I asked her what would make for an exceptionally successful event, and she ventured that if Elizabeth Warren were to write a book on Wall Street, perhaps up to 100 people would show up. But that a legal academic book on some obscure 18th century Italian thinker is a different story. Well, we set out to prove that Cesare Beccaria, pronounced correctly, or at least John Bessler, is just as popular as Elizabeth Warren, and I'm happy to report that at the last count we are very close to 100 attendees. Speaking of reporting headcount, I would also like to thank and commend from the depths of my heart the indefatigable and undefeatable Trisha Gross in the back, and also Max Medina from my firm, Foros, and the Strand staff for all the effort they put into organizing this event and achieving a very successful outcome. Two introductory comments, if I may. First, Cesare Beccaria. Not a long time, I had never heard of the man. And I'm sure many of you have never heard of the man. Thanks to John, his terrific book, and other massive reading he assigned to me over the holidays, I know more about him today than I know about almost any other historical figure. And what a story it is. Here is someone who emerged at a critical juncture in the world intellectual history, when we transitioned from a deeply traditional ecclesiastic and authoritarian worldview, at least in the West, to the modern era of progressive empiricist rationality, and who made a major contribution to law and economics. Peter Groeneweggen's 18th century economics, Turgot, Beccaria, and Smith, and their contemporaries, another assigned book to me, is an important book on Beccaria's role on economic thought that places him as an intellectual peer of Adam Smith. So one question we should explore: why do we all know Adam Smith and not Beccaria? Importantly, Beccaria has had a tremendous influence on America and its founding. For the lovers of strict constructionist interpretations of the Constitution, and I'm sure there are many of them in this room, that was another joke. No, this makes for fascinating reading, because as it turns out, our founders were not the decapitation-loving, capital punishment and torture embracing militia that emerges from reading Justice Scalia's judicial opinions. But rather, they were fledgling progressive who harbored deep reservations about capital punishment and torture, and sought to develop modern approaches to punishment. And their progressive thinking was deeply influenced by widespread and thorough reading of Beccaria's work. John's book does an excellent job in bringing Beccaria to life as a person, situating him in the 18th century European intellectual history, and documenting his influence on America's founders and the noble experiment they embarked on. I will leave it to him to say more about that, but I assure you, you will not get the full story without reading the book, and you won't be able to read the book without buying it. In case it is not clear to everyone here, book events are occasions to sell a book, in part to show appreciation to the author for his labor of love. 10 years ago, we held a book party to celebrate the book Rebecca had written over the course of several years, and we were quite surprised that the number of books sold was far fewer than the number of attendees. Well, we know exactly how many of you are here. The Strand has a magic number of books, and thanks to Amex, MasterCard, Visa, Google, Amazon, Uber, the TSA, NSA, NYPD, and CIA, we will know who among you bought the book, whether you took it home or to a lover, that's where Uber comes in, and which pages you read and which ones you skimmed. So please wander to the table in the back during the talk or immediately afterwards and purchase a copy. John will autograph the book here as well as at the invitation-only after party. Please save the conversation to later in considerations for those waiting in line for the autograph. Okay, based on my homework, I might have a word or two to say about Beccaria's contribution to economic history, and one excellent additional book I recommend is Bernard Harcourt's The Illusion of Free Markets, another one of my assigned readings. But I know you did not come to hear from me, but from John, so let me introduce him formally before yielding to him. John is a native Minnesotan from that great state that has produced such amazing people as Hubert Humphrey, Walter Mondale, Eugene McCarthy, Amy Klobuchar, Bob Dylan, Prince, and Rebecca Haile. He attended the University of Minnesota and spent the bulk of his life there, but now splits his time between Minnesota and Washington, D.C., and teaches at the University of Baltimore School of Law and at the Georgetown University Law Center. John has emerged as one of the foremost experts on the Eighth Amendment. This is the amendment that prohibits cruel and unusual punishment. Though several versions of it in state constitutions, such as California's and Hawaii's, prohibit cruel or unusual punishment. John would be happy to educate you on the difference between prohibiting cruel and unusual punishment versus prohibiting cruel or unusual punishment. I'm speculating with limited knowledge, but I would assume exposing someone to overly funny French cartoons would be disallowed as unusual punishment, but might not constitute cruel. John is also an expert, that didn't work, right? John is also an expert on death penalty law and has written several books on the subject, including Cruel and Unusual, The American Death Penalty and the Founders' Eighth Amendment, Legacy of Violence, Lynch Mobs and Executions in Minnesota, Kiss of Death, America's Love Affair with the Death Penalty, and Death in the Dark, Midnight Executions in America. In particular, John has made a very compelling case that the well-intentioned efforts to prohibit public executions have had the inadvertent impact of shielding the death penalty from public outcry and have prolonged its existence in our penal system. You could imagine that some of you would feel differently about the death penalty or more strongly against it if leaving this reading and on your way to dinner at Union Square Cafe, you passed 10 scaffolds with a number of convicts hanging from them. John is an advocate of greater transparency for executions. I have admired John for his prolific writing. I wanted to be a writer academic myself when I was a younger adult, but I could not overcome writer's block as I let excellence get in the way of good enough. I became a banker instead, which has been, well, good enough. When I shared that story with John over dinner one evening, he said, "No problem, I have a solution for you." Next, I got in the mail a book entitled Writing for Life, The Craft of Writing for Everyday Living. Author, John Bessler. John is not only a prolific writer, but one that has figured out how to achieve excellence in that craft, and for that I admire him. Without any further ado, I'm happy to yield the floor to our dear friend John Bessler.
Well, this is an amazing turnout, and John and Rebecca, thank you so much, and Nancy, thank you so much for hosting this. This room is quite incredible, and this book that I'm writing about a book in this book, and the book was originally published. The 250th anniversary was last year, 2014, of this Dai Delite e del Pene was the original book in Italian, which was translated into English in 1767. As On Crimes and Punishments, or as an essay on crimes and punishments. And I came to this subject because Beccaria was the first writer to write against the death penalty. He also wrote against torture. And so that was my entree, because I've done a lot of work advocating against the death penalty. And so I discovered him, but I discovered the story was actually much larger than just the death penalty. And there's a lot of interesting connections between Italy and the United States. In fact, if you go to the U.S. Capitol and you look around, you'll find a lot of Italian art there. There's a lot of Italian influences in the United States, and so it's probably not too surprising that also in the legal arena, Italy might have also played a role in influencing the early founders. And so what I'd like to do to start is just to tell you a little bit about who Beccaria was, so you have some sense of him as a person, and then talk about the influence of his book that he wrote on the American founders and on American law, and then hopefully we can have a conversation, and because I think that his writings are still very important to think about today, even though they were written 250 years ago, they still have some currency today. And even among lawyers, of which I'm one, back in law school, I never heard of this person before. He's still read in some criminology courses. I talked to a criminologist and said there's maybe a paragraph about him in a criminology textbook, but there's really not a lot of information available to the general public about his influence on American law. And so it's been sort of a forgotten influence. So Beccaria was born in Milan in 1738, and he died in 1794. So he died during the middle of the French Revolution, and he died sort of as a forgotten figure, essentially, when he died. And I'll talk about why that might be. But his early education was in Parma. He was taught at a Jesuit school, had a very conservative kind of education. And then he went to the University of Pavia and got a law degree, finished that law degree. And then at age 26, he wrote this book, Dai Delite e del Pene, which was originally published anonymously because of the fear of the Inquisition. And back then, not so safe to put your name to your ideas necessarily, especially if you're advocating against something like the death penalty, which had been such a standard part of the society at that time. But Milan was one of the centers of along with Naples, was one of the centers of the Italian Enlightenment. And in Milan, there was that was then part of the Habsburg Empire. Italy was not a unified country at that point. And so at that time, the count who was sort of in charge, who was described as the king of Milan, essentially, took a liking to Beccaria's ideas, and they were reformist ideas, and decided he was not going to, put him under the Inquisition. He was excommunicated from the church, actually, so in terms of his viewpoints, they were considered to be sacrilegious. His views and too rationalistic. But in the enclave of Milan, he was actually given protection in that area. So he wrote this book on crimes and punishments in the original Italian when he was just 26 years old. And it was part of a group. Back then, people really had a lot of conversations through coffee houses. And there was a journal that Beccaria and some of his peers were involved in called the Il Cafe was the name of the journal, and they had a social group, sort of social club, which was called the Academy of Fists, or in sometimes some translations you see it as the Academy of Punches. And the idea was that they had such pugilistic debates that they would almost come to blows during the course of their discussions about intellectual issues. And as John points out, Beccaria was first and foremost really an economist. And his mentor was a guy named Pietro Verri, who wrote in 1763 a book called Meditations on Happiness. Okay, and Verri was an economist who would go between Milan and Vienna, and Beccaria, after he wrote this book, also became a civil servant and went from Vienna to Milan, but mostly was based in Milan, was part of the Supreme Economic Council. And he was one of a very few lecturers on economics, and he was appointed after this book was published. He was asked to provide service to Catherine II in Russia. He considered that for a time, but then turned it down after the folks in Milan offered him a position teaching economics. And so his economic writings were published several years before the Wealth of Nations book was published. And so there's an Austrian economist, Joseph Schumpeter, who actually called Beccaria the Italian Adam Smith, although their economics were a little bit different. And because he came before Adam Smith, they actually called Adam Smith the Scottish Beccaria in exchange. So this book was published in as I said, 1764, translated in English in 1767, and it became a worldwide bestseller. It was translated into 22 languages. It was translated into French by the same translator who later translated Jefferson's Notes on the State of Virginia, and it was translated into Spanish, Portugal, all the major European languages, and it found its way into the Americas. And I've done further research and found that it was not only influential in the United States, but also in all the way from Canada down to Argentina. So it was a very influential book at the time. So if we look at the American influence, George Washington bought a copy of this book in 1769 along with Thomas Jefferson, same year. And George Washington bought a copy for his stepson, indicating that clearly this was a book that any educated person would have to read at that time. And in his own correspondence to the Continental Congress, he argued that punishments needed to be proportionate. Washington argued that, and it was the very same argument that Beccaria had made in his book. So in Beccaria's book, he argued against the death penalty and against torture. He argued for more public education. He argued for against dueling. There's a whole array of things that are listed in his book, but it's mainly a criminal law essay. John Adams actually quoted Beccaria's book at the Boston Massacre trial. And he quoted the Marquis Beccaria and said that if he could save but one life, that would be the consolation to Adams for the rest of his life. And clearly this was a book that was in such, the public was so aware of it that Adams felt comfortable quoting it actually at the Boston Massacre trial. And his co-counsel Josiah Quincy also quoted the book during the course of that trial. So we had the first U.S. president reading the book, buying the book, and using the book, using the ideas in his writings. Adams, the second president, also quoted the book, and you'll find actually entries in his diary. And I found that there's several of the original founding fathers actually spoke or read Italian to one degree or another. John Adams, Thomas Jefferson, Benjamin Franklin, James Madison corresponded with some folks in using Italian, and Jefferson himself copied 26 different passages from this Beccaria's book into his commonplace book, which was the kind of book that lawyers would use to provide their own education. They would write down any significant ideas that they could then use for later. And Jefferson, toward the end of his life, when he was writing an autobiographical statement, said that Beccaria had convinced the reasonable world of the inefficacy and unrightfulness of the punishment of death. And so Jefferson also recommended this book to many other aspiring lawyers, and actually wrote a book, wrote a draft legislation in Virginia that was the title of which was to proportion crimes and punishments. So the very title of the legislation that Jefferson drafted in the 1770s mirrored the title of Beccaria's book, and in fact you find that there is citations to Beccaria in Jefferson's draft legislation. Jefferson was tasked with revising the penal code in Virginia, and so he undertook that. And then Madison, while Jefferson was actually in France as a diplomat for the United States, carried Jefferson's legislation in Virginia. It failed by just one vote, and this prompted Madison to say that our old bloody code is by this event restored. And the bloody code, of course, was the English bloody code, which made over 160 crimes punishable by death at that time. Now, I see that my wife, Amy, has come in, so thank you for...
I'll read it.
So if we go back and look at how this book influenced beyond the realm of crime and punishment, and again, Madison himself actually said that Beccaria was at his zenith as a philosophical legislator back in the founding time period. So you see references being made by all the significant early founding fathers to Beccaria's work. And the list goes on and on, actually. John Hancock owned a copy of the book in his library. There was Dr. Benjamin Rush, who was a physician from Philadelphia, would quote this book extensively, in fact, to the point where I've seen some historians call Dr. Benjamin Rush the American Beccaria. He was also against the death penalty. And then you have other figures in the early American history that were also referring to Beccaria's ideas. And so really, this is all over the record. So one question you might ask yourself is, well, why have so few of you heard of this figure at this point in time if he had such a significant influence? And the reason actually has something to do with New York, believe it or not. In the Federalist Papers, which were written for a New York audience to ratify the Constitution, John Jay, Alexander Hamilton, and James Madison wrote the Federalist Papers. You do not find a reference to Beccaria in those papers. You find 4 Federalist Papers that make specific reference to Montesquieu. Montesquieu was the French writer who wrote a very influential book that actually influenced Beccaria. Montesquieu's book was called The Spirit of the Laws. That book was written in 1748 and was published in English in 1750, and that was, again, a very important book. The founders would continually refer to Montesquieu as the celebrated Montesquieu, the immortal Montesquieu. These are some of the same sort of praise that's also given to Beccaria, by the way. But because Beccaria was omitted from the Federalist Papers, the kinds of things that school children read today about the Constitution, they never really encounter Beccaria in their studies. They see Montesquieu, and so if you read the Federalist Papers and only the Federalist Papers, which were really just designed for that New York audience, published in the newspapers in New York, you would think that Montesquieu was the star of the time. And in fact, Madison called Montesquieu the oracle on separation of powers, the idea that legislative branch, executive branch, and judicial branch should be separated, and that was a big concern about making sure that nobody had too much power. But in fact, the Constitution was focused on the structural aspects of government at the federal level, whereas Beccaria's book talked about making punishments less severe. His idea was to make punishments certain, but to make them less severe. And that the law itself, he thought, should reflect the fact that we do not want judges making arbitrary decisions. So, of course, a lot of people think that the United States comes from, as the common law. People still refer to England as the mother country, right? And somehow all of our laws just come from Great Britain. But of course, during the American Revolution, we were fighting Great Britain. So it's not too surprising, actually, that the founders were not too keen to just adopt everything that England used. And so the founders came to view the kind of severe punishments that were being used in England as sort of a feature of a monarchical system. And it was actually referred to as a sanguinary system. And the United States moved towards a penitentiary system instead. And we opened the first penitentiary in the United States in Philadelphia, the Walnut Street Prison, in 1790. So just a year before the U.S. Bill of Rights was put into place. And you see, if you look at the literature on penitentiaries, that Beccaria actually provided the impetus for the creation of the penitentiary system, because if you weren't going to kill people, you needed a place to put people in response. And also this idea of making laws less arbitrary. So John Adams was famously involved in drafting the Massachusetts Constitution of 1780, which is the oldest continuously operating constitution in the United States. And in that constitution, he referred to the idea that we want to have a government of laws, not of men. And that idea really comes directly from Beccaria's writings. He argued for a fixed code of laws, written laws, clear laws that people would know in advance, so you wouldn't have judges making arbitrary decisions sort of on a whim in individual cases. Beccaria also, because he was an economist, talked about a lot of other things as well. And one of the things that he talked about was maximizing people's happiness. And of course, if you look at the Declaration of Independence, you see that idea of the pursuit of happiness showing up as well in the Declaration of Independence. So there's a lot of different influences that show up. And to show you how significant his writings were, if you go back to 1774, remember the Revolutionary War starts in 1775. In 1774, the Continental Congress, as an entire body, writes a letter to the inhabitants of Quebec, trying to get the people of Quebec on their side against the British. And in that letter, which is sort of a propaganda letter, there are two major writers referred to in that letter. One was Montesquieu, and the founders thought that would appeal to the French-speaking people of Quebec because he was French. But the other was Beccaria. And in that letter, the quote that they pulled out of On Crimes and Punishments, Beccaria's book, said something to the effect that in every human society there's a tendency to give power and happiness to one group of people and to reduce the other group of people to misery and weakness. And so this idea of equality really runs through Beccaria's ideas, the idea that the law should apply not just to poor people, but also to the nobles themselves, that there should be equal treatment under the law, which of course we find only coming into the U.S. law later, after the abolition of slavery, with the 13th Amendment, and with the 14th Amendment, equal protection of the laws. The Civil War, unfortunately, sort of obliterated Beccaria's more humane influence because of the over 600,000 people were killed during the Civil War. So if you look at the newspapers during the Civil War, and I've done searches, you find no references to Beccaria during the Civil War. And that's where I think his influence and star sort of faded. And again, when you couple that with the fact that he's not mentioned in the Federalist Papers, you can have some understanding of why this figure is no longer remembered so much today. But back at that time, his star was at its zenith, and he was one of the major figures that really inspired the American Revolution. Thomas Paine himself, who wrote Common Sense, was against the death penalty, would have been a reader of Beccaria's work. The list of founders who read this book and were influenced by it is literally just goes on. And part of it was that it was a very short book, unlike this book, which is about 700 pages if you include the index. Beccaria's book was about 100 pages, and it was written in a very accessible style, as I hope my book actually is, written in an accessible style, to tell the story of what happened here. But it was a book that was available not just to lawyers, but to non-lawyers as well. And so actually you'll find advertisements for Beccaria's book back in the founding period in agricultural journals. This was a book that was read by a wide swath of people. And just to give you a few more sort of facts about this influence, and then we'll maybe move to some questions. There was an Italian botanist whose name was Luigi Castiglione, who came to the United States for 2 years. He traveled throughout the United States and into Canada. It was during the period from 1785 through 1787. And he was a botanist, so he was coming here primarily to study plants and to look at the social customs. But the Italians were fascinated by the American Revolution that had occurred, and the Americans, in turn, were fascinated by that idea of Rome and the Roman Republic, and trying to figure out what went wrong with the Roman Republic and how they could craft a system of government that would be one that would be long-standing. And they were fascinated by the Italian Enlightenment. In fact, Jefferson went through and traveled through northern Italy in 1787 for about 3 weeks. And there was other Americans that also traveled to Italy as part of a grand tour that they would do, usually after they were educated in Scotland or in London. But Luigi Castiglione wrote a book in Italian. It was called the Viaggio. It was a travel log that was written after he got back to Italy. It was published in Milan in about 1790. It was not translated into English until 1983. But Luigi Castiglione was in the United States right before the Constitutional Convention in Philadelphia in 1787. And so he was here at a formative time, and he met with kind of a who's who of the founders. He stayed at Mount Vernon for 4 days, and he was a nephew of Pietro Verri, who was the economist that was Beccaria's mentor. Verri was about 10 years older than Beccaria, but he was a mentor to Beccaria, and so he was in the same social circle as Beccaria, and he traveled around. He met with, again, a who's who of the founders. And when he was in the United States, William Bradford, who was then the Attorney General of Pennsylvania, where a lot of the activity was going on, wrote a letter to Castiglione and delivered to him a copy of Beccaria's book that had been published in the United States. And the letter effusively praises Beccaria's book and says what an impact it has had on our laws, and in fact Pennsylvania laws. The Pennsylvania Constitution reflected directly Beccaria's influence, was it called specifically for proportionate punishments in that document. But there was also, Bradford referred to the influence that Castiglione must have seen in the other states as he traveled, because the influence was not just limited to Pennsylvania. It was expanded throughout the original 13 colonies, became states, and Beccaria's work was really reprinted in magazines and reprinted and sold in books. So his ideas were really transmitted. There was debates at colleges, etc. But in that letter, Bradford, who became George Washington's the second Attorney General of the United States, just goes on and on and on about the influence that this book had. And it's buried in kind of a obscure, endnote to this translation, this letter. And so what I'm trying to do with the book is really to try to revive the discussion about the impulse that the founders had at the beginning of this country, because when people think about the Constitution, it's interesting to think that the Constitution is revered as the seminal document that everybody in the United States looks to, right, to resolve things. And actually, Beccaria's idea about having written laws has given us a great advantage in the sense that we have a stable system of government which has allowed for economic development, which is one of Beccaria's other major concerns, was how do you increase wealth in a society at the same time that you protect human rights, essentially. So this was a book that was very important, and so I'm trying to revive the currency in the book and kind of bring back the impulse that the founders had towards a progressive kind of agenda. Of course, back at the founding year, we had slavery, so we can't say that the founders were totally progressive, but they were looking to the future. They were looking to how things might change, and the penitentiary system was creation of that system was just one aspect of that forward-looking thinking that they were embracing at that time. And the fact that the founders were looking to a writer who was writing against the death penalty and calling for punishments that were more mild, more certain, but more mild, I think is something that we as a society should be thinking about as we think about our current state of affairs. With the U.S. has been described as having mass incarceration. There's a lot of issues beyond the death penalty that we're incarcerating people that are maybe nonviolent offenders. And one of the key findings I found in the book was that both Montesquieu and Beccaria, the two sort of leading lights that the founders looked to during the American Revolution, both articulated the fact that any punishment that goes beyond absolute necessity is tyrannical. That was the language that they used. So I think that's a very interesting thing to think about as you think about the original intent of the Founding Fathers. And it makes for an interesting question that, for example, Justice Scalia that John referred to would I think have to think about, at least, in thinking about an originalist version, a vision of the Constitution. All right, I'll be happy to take any questions you might have or any discussion. Yeah.
As someone who looks forward to reading your book and very much admires Beccaria, though disagrees with him fundamentally, I wonder whether you might correct what I see as a misstatement in one of the blurbs on the book. The blurb says that Beccaria was a leading opponent of corporal punishment. As I'm sure you know, and as I can quote having the essay in my hand, on chapter 22, Beccaria says, and I quote, "When robbery is attended with violence, corporal punishment should be added to slavery." And so I think any fair reading of this essay, while it will acknowledge that he was a leading opponent of the death penalty, would also have to acknowledge what the blurb denies, which is that when there's gratuitous violence that is accompanying robbery, corporal punishment as a like-kind punishment is the appropriate response.
Well, there's obviously, and even the death penalty, Beccaria was not, he would not say he was completely, in all circumstances, ruling out the death penalty. Remember, this was an idea, a theoretical idea at that time. And one of the things that you see in the early American period is that this is referred to as the Beccarian experiment. There's some letters that refer to this Beccarian experiment that was taking place. So his ideas were untested. So the idea was that people would try his ideas. And William Brad, for example, wrote an entire essay called An Inquiry into the how far the punishment of death is necessary in Pennsylvania, picking up on that idea about absolute necessity. So I think he did have some things in his book about corporal punishment, but that core principle that said that any punishment that goes beyond absolute necessity is tyrannical would say that certain corporal punishments would be unnecessary. So it's kind of a mixed bag, like it is for the death penalty. For the death penalty, he actually said that if you actually had somebody who was in prison that could risk the downfall of the government, in that limited circumstance, he was willing to consider the death penalty. But now today, if you translate that into today's society, that would be like saying if somebody was in prison in a penitentiary, could they somehow overthrow, say, the governor of, if we're thinking about Maryland, until recently here, the governor of Martin O'Malley in Maryland, Maryland just abolished the death penalty. And so I think that if you look back at the corporal punishment issue, you see that there actually is, John Hancock actually proposed getting rid of the whipping post, getting rid of branding, ear cropping. All of these were punishments that were bodily punishments that were used back at that time. But we saw that the founders began to curtail bodily punishments. They didn't completely eliminate them. And the same thing is true with the death penalty. They curtailed the death penalty during their time, but the penitentiary system was not fully developed yet. The penitentiary system really came of age during the era of Andrew Jackson, and you have a lot of penitentiaries being built. The Walnut Street Prison was in 1790. Virginia started its penitentiary in 1800. Massachusetts, Maryland in the first decade of that new century, and a lot of the penitentiaries didn't come online until the 1830s, 1840s. So these ideas again were ones that were being tested, being experimented with, and so I think it's fair to say that the corporal punishment issue, like the death penalty, it was a mixed bag for how that was implemented.
If I could just have a quick follow-up and then I'll be silent.
Sure.
The position about acknowledging the death penalty when it's absolutely necessary to suppress a rebellion is, of course, actually the Church's position, which is not absolutist, the Catholic Church, against the death penalty, but allows for that one exception. But Beccaria specifically says that where robbery is accompanied by violence, there should be corporal punishment in addition to slavery. So he presupposes that there will be prison. And notwithstanding the fact that it's not an escape risk, he proposes corporal punishment because he says elsewhere in the essay that punishment should as nearly as possible resemble the nature of the crime. And therefore, when the robber gratuitously injures his victim, Beccaria calls for corporal punishment beyond what's necessary to imprison.
Yeah, I think that where we're maybe having the hang up here is that I think there was a difference of opinion back then as to what was necessary, what was actually necessary. In some cases, corporal punishment was seen by the founders as necessary. And I think when we ask ourselves that question today, though, about what is actually necessary as punishment, we may reach different conclusions than they did back in the 18th century. And one of the things that I have always had a problem with in terms of an originalist vision of the Constitution is that if you think back to the original vision of the Constitution, that would mean that slavery would still be allowed, right? And of course, the 14th Amendment and the 13th Amendment now outlaw that. We now have equal protection of the laws. But back in Virginia, in the early part of this country, there was actually a different criminal code for whites than there was for blacks. Frederick Douglass actually gave a very moving speech on the anniversary of the July 4th. He was speaking to a group, and his basic point was, look, you have to look at this document when you're having these celebrations a little differently if you're in my position. Because in Virginia, there was over 70 crimes that were punishable by death for African Americans. There was 2 for whites. And so there's been a sort of a sea change, and there's actually a court case from Virginia actually that said that, well, African Americans, they're not entitled to the protections of cruel and unusual punishment at all. That protection in the Virginia Declaration of Rights did not apply to them. So if you ascribe to an originalist vision of the Constitution, I think there's a lot of morally questionable things that you run into. Yeah, please.
Beccaria was a proponent of the penitentiary system. If he arrived on our shores today, what would you think of for-profit prisons?
Well, I mean, I've thought a little bit about that question myself, actually. If you're running a prison corporation and you have to report to your shareholders, your fiduciary duty is probably to increase profits for your corporation, which is contrary to the idea of having a system that does not want to encourage people from coming back to prison. That you want to not have repeat customers in prison, right? So, but the privatization of the prison system, I think, is troubling in that respect because the incentives are really very perverse. In fact, I've read some things talking about how some states that guarantee that a certain number of beds will be filled. That doesn't seem to make a lot of sense to me. And I think as a society, we have to think long and hard about the use of punishment, that when punishments are not necessary, that it may be problematic for our society. We're losing productivity of people. We're sort of, putting people in situations where they're not going to, when they come out, they may not be reformed. They may even be worse than they were when they went in. And so a state like Minnesota tends to use more probation. We put people away that are violent offenders, and I think we need to do that. But for the nonviolent offenders, I think we be very careful about how much we use prisons. Yeah. Ted?
John, there's lots of topics that you've touched on already, and 2 that strike me as pleasant is how it is that someone like myself, who thought I was knowledgeable about American history.
You're a Yale professor, right?
Believe that? That's not. What I want to concentrate on is this problem of why we didn't know anything about this person. What do the scholars of American constitutional law say about this topic? What do the historians of the founding fathers? Your story here is new to me, and I spent plenty of time. It's not my main concentration. None of the scholars that I've known have ever mentioned this. So that's question number 1. And there's a puzzle then. And the second one is the discussions of the founding fathers, with lots and lots of biographies and joint biographies and histories. You've given us a lot of evidence that in the words of the founding fathers, this was one of the influential matters. So what happened to that among the scholars of American history?
Well, it is curious. I mean, I think that part of the issue is that maybe people had particular views that wanted to de-emphasize Beccaria's views, but it really was a foundational text in the sense that the founders were looking for a fixed code of laws, and that's what they use. And so that's really the civil law model, is actually to have codes, not to rely on judges so much. And so there was actually, I think it was Jefferson who said that the judge should be a mere machine. The law should be so written in such a clear fashion that the judge does not have to engage in a lot of discretion. The judge just simply looks at the facts and decides, do these facts either violate the law or not violate the law? Calls balls and strikes. And Justice Roberts, in his testimony, it was sort of along that line, right? So, but the written laws were supposed to be clear and precise, and that's exactly coming out of Beccaria's work.
But does it connect, to just follow up this, does it connect to your earlier point, which I thought was interesting, about Montesquieu? To the extent that the constitutional period was preoccupied with institutional design, not public policy positions, you can imagine that cleavage would separate Beccaria out, and thus those scholars interested in understanding the Constitution that emerged, rather than the intellectual apparatus of the Founding Fathers, might have put it off in, so to speak, the criminology area, and with common law becoming the dominant one, push the civil law element. That's the aspect.
Well, I think one of the things that I think happened, and I mentioned the Civil War, and the Civil War really coursed in society, and so Beccaria's sort of more humane vision sort of got lost in that shuffle of the Civil War, which was a huge, obviously, event in American history. But because of the title of his book, it talks of crimes and punishments. Yeah. When people look at the book, they think, oh, this is about crime and punishment, and they move it over in the criminology section of the the bookstore maybe, or in courses. They don't really think of it as a foundational constitutional sort of figure. But if you look at the way that the founders themselves talked about Beccaria, and the idea of maximizing happiness, Bentham actually refers to, Bentham wrote an essay called A Fragment on Government in 1776. The same year we issued the Declaration of Independence. And Bentham, who had correspondence with James Madison, and who was a revered figure in his own right, sort of the founder of utilitarianism, said that when Beccaria came, he was received by the intelligent as an angel would be by the faithful. William Blackstone, who was a seminal figure in English law, who the founders read widely, referred to Beccaria as an ingenious writer. And this idea of tyrannical practices, and Beccaria opposing tyrannical practices, that's what the founders felt like they were experiencing. They were experiencing tyranny at the hands of the British, this idea of taxation without representation. And so when his book appeared in the 1760s, and it was first published in Italian in 1764, the Stamp Act was in 1765. And the book was translated into English in 1767. And so it came at an amazingly important time in American history. Because it inspired the founders to think that they did not have to withstand these kind of tyrannical practices. And that was really an impulse that really moved the founders, and it also inspired other writers as well. So I've mentioned Beccaria, but there's a lot of other figures in this book as well. Like there's a guy named Gaetano Filangieri who wrote a book called The Science of Legislation in the 1780s. And Benjamin Franklin had direct correspondence with Filangieri, who corresponded himself with Beccaria. And the idea of the Science of Legislation book was that Beccaria's ideas were theoretical. Filangieri wanted to actually create an actual code like Bentham did for other countries as well. Bentham was very much into writing codes. And actually maybe I will also say that in New York City, one of the main figures that was really revered was the former mayor of New York, Edward Livingston. Edward Livingston was related to one of the original 5 members of the Committee of 5 that drafted the Declaration of Independence. And Edward Livingston was the U.S. Attorney for New York and a mayor of New York, went down to Louisiana to craft a criminal code for Louisiana, was very much inspired by Beccaria's work, and he was producing a code, and actually, in his case, and this is a horrible story for a writer, but he both finished his project and it was destroyed in the same day. He finished this very lengthy project, and then a fire consumed his work, so he had to start over again. But he was opposed to the death penalty, became a U.S. Secretary of State under Andrew Jackson, and so I think until the period of the Civil War, he still was somebody that was talked a lot about, but during the Civil War, everything sort of fell apart. And at that point then, and because he was not mentioned in the Federalist Papers, he gets forgotten, or it gets put over in this little track about this is just about crime and punishment.
Just to follow up on that, can you expand a little bit more on that, the influence that it had on that gap generation between the founders and the Civil War? You know, that 1820 to 1860 period, aside from Andrew Jackson, like the secretary, but what other cultural or political or civic influences did it really have?
Yeah, it had, first of all, there was the influences were on the state constitutions. Quite a number of state constitutions not only prohibited cruel and unusual punishments, but actually prohibited punishments that were disproportionate, which was coming direct from Beccaria's work. There was also some influences on, dueling, but I found evidence that his work was actually referred to in all sorts of contexts. People talk about the need for education of the citizenry, to be informed. He was actually in 1784, and then I'll move into the period you're talking about. In 1784, he was nominated to be an honorary member of the Constitutional Society of Virginia, which is the purpose of which was to educate the public in Virginia about their constitutional rights. And members of that body included James Madison and John Marshall, and just a whole host of very influential figures. So the idea that, and he was nominated by a guy named Philip Massey, who was an Italian who came to Virginia to start a grape growing operation and was Jefferson's neighbor, and Jefferson and this guy were very good friends. He actually became a citizen of Virginia and later performed some diplomatic service for the country as well during the Revolutionary War. But during this later period, you find that the reports on the penitentiary system, and this really is an obsession of the founders. In fact, Jefferson designed some of the plans for the penitentiary in Virginia. It was an obsession of the founders. The leading architects were the ones designing the prisons, because this was seen as sort of very important work, almost God's work in a way, and there was a lot of religiousness, of course, during that time period as well. But people like John Quincy Adams sent a letter to the Committee to Abolish the Death Penalty nationally. John Quincy Adams actually had referred to, when his father had quoted Beccaria, John Quincy Adams said that it had an electrical effect in the courtroom. So the amount of influence that Beccaria had continued on through the 1830s and 1840s. You still find a lot of references to his work during that time. And the only reference I've actually found immediately after the Civil War, a group of Italians, including a guy named Giuseppe Garibaldi, who was one of the leading figures in the unification of Italy, signed a petition that was presented to President Johnson after the Civil War, asking President Johnson not to execute Jefferson Davis, the Confederate president, and quoted Beccaria. And actually in Milan, there's now a monument. If you go to Milan, you'll find a monument to Beccaria in the streets of Milan, in a very commercial district. I have a friend in Paris who just recently was on this march after all the terrorism there. Sent me a photo of a street sign, the Rue Beccaria in Paris. So Beccaria's name is still remembered very much in Europe, but kind of forgotten in the United States, at least among the average lawyers. He's still maybe read a little bit in the criminology departments, but beyond that, it's really not a major focus. And I think that's a mistake, because Montesquieu and Beccaria were really cited side by side as equals back at that time. Yeah, Mark is my former student, and actually was a research assistant and clerk for Justice Kennedy. So thanks for being here, Mark.
Yeah, thanks, John. My question for you is about that concept of necessity you were mentioning before, and the idea that any punishment beyond what's necessary is tyrannical. But I'm curious how Beccaria would have defined necessity. Was it that individual person, or just deserts punishment for them for what they've done, deterring them from the future, rehabilitating them, broader deterrence?
Yeah, his focus was on the prevention of crime and wanted to prevent crime, and you see this in the in the people that quoted Beccaria that talked about this was a maxim that they had adopted, that this was the only purpose of punishment was to prevent crime. But as our discussion earlier kind of pointed out, there was definitely some disagreements as to what was necessary. And in fact, when we look at William Bradford's report about this inquiry to the necessity of the punishment of crimes by death, Bradford goes through a series of crimes, rape, a number of crimes, and concludes that for those crimes, other than murder, the death penalty was not necessary. But Bradford decides that we need more evidence on the necessity of the death penalty for murder. We just don't know yet. So they're very much looking for empirical evidence. I think one thing interesting to think about today, when you talk about, I know that John, we began this session by talking about cruel and unusual punishment, but back then you could not say that the death penalty was cruel and unusual. The death penalty was a mandatory punishment for various crimes, including murder. So it clearly was the usual punishment. But today, if you look at the statistics, we now in this country have over 50,000 people serving life without parole sentences, true life without parole sentences in the United States. And you compare that to about 3,100 people on death row. So if you ask yourself what was the usual punishment today, I would think you would have to conclude that the usual punishment is life without parole, not the death penalty. And so that's just an interesting thing to think about in terms of how the law, which has remained the same, may be interpreted in a different manner as society evolves over time.
So it turns out in Hollywood, all the successful movies are the ones that have sequels. So we will look forward to the sequel of Beccaria's book. I think as we're bringing this portion of the evening to a close, Rebecca, do you have one last question that you want to ask?
Can I ask one?
Yes, you can ask one. You get the prerogative of the last question, and then Amy gets the prerogative of the last comment.
The last word? Okay.
Well, my question was, when you speak of the coarsening impact of the Civil War, the thing that immediately comes to mind to me is what's happened post 9/11 and our attitudes about sort of crime and punishment there. So the question is whether there are particular formulations that Beccaria had of his arguments in favor of progressive liberalism in this area that might fall upon ears now, given the environment that we're in post 9/11.
Yeah, I mean, I think there's so much in his book that addresses such a wide range of subjects, and of course, it's hard to. When you're living when writing this book, I felt like I was living in the 18th century at times because I was reading all these writers, and of course, a lot of them have views that you think, well, that's absurd, or they're debating slavery. I mean, my goodness, this is clearly a different time period in our in American history. But I think that the sort of the humane vision of not using more punishment that you need. And thinking about, this was actually something his mentor, Pietro Verri, also talked about. They were obsessed with this idea of pleasure versus pain, and this idea of public happiness was an attempt to minimize pain. And Jefferson himself picked up on that idea, that the need to minimize pain was Jefferson referred to that as the art of life, as the art of minimizing pain. And I think that an important thing to remember is that, the crime is about what the offender does, or the terrorist does, or what the murderer does. But the punishment should reflect the societal values, the society's values as a whole. And that's something that I think people need to at least keep in consideration. Now, there's obviously a lot of different views about the death penalty that people probably have, but it's at least something to consider when you're thinking about these issues, is that, punishment is serving a different purpose. The criminal, it probably is not a rational actor, right? If you're committing a murder, you're involved in some sort of terrorist act, you're not acting in a rational manner. But the society's response should be, I think, should be proportionate. First of all, that was a core principle that the founders themselves embraced, but they should also be thinking about their own values and how they want to live their lives, as opposed to how the terrorists or criminals want to live their lives.
One thing that I found very interesting reading the book, and also reading the accompanying reading, is the way in which during this period, the whole bifurcation of the markets and the state emerged, the public-private distinction, and how the markets or civil society was viewed as the realm of freedom, and then the state and violations, theft, evading custom tariffs, whatever, were viewed as the realm of crime, and two different rationalities began to apply to those two realms. That was dramatically different. That was different from a system in which there is a single sovereign who governs the economy in a mercantilist way and governs punishment in a similarly mercantilist, whatever, whatever, the king, whatever, the state is mean. That sort of started bifurcating, and that whole debate was playing out between Beccaria, the economist, and Beccaria, the penalist, and that was true for Bentham and others, right, throughout this period. So it's interesting to relive that discussion because of all sorts of implications it has